Ladies and gentlemen, I'd like at this time to take the opportunity to introduce to you the members of our panel that will be speaking to you this morning. On my far left, Mr. Claude R. Thomson, QC of Toronto. Claude is a graduate of the Osgoode Hall Law School. He is a member of the Law Society of Upper Canada. He's a member of the Bar of Alberta, obviously intended to cut his losses if there are problems here, and a member of the Bar of the Island of St. Helena, which Claude very candidly explains is intended to protect his fishing rights in the south. He is a partner in the Toronto law firm of Campbell, Godfrey and Ludis, which is the practitioner's equivalent to the Harvard Law School, and he is one of Canada's preeminent general counsel. Keeping our priorities straight, Claude's first love, even before the law, is fly fishing, which he excels at, as he does at the practice of law, and I can assure you that around the Quebec trout lakes, when they speak of Big Claude, they're not talking about Claude Ruel. So I'm very pleased to have Claude Thomson with us here this morning. On my far right, we have Bruce W. Binning of Toronto. Bruce is a graduate of the Osgoode Hall Law School. He's a partner in the Toronto firm of Matthews, Dinsdale, and Clark. He restricts his practice to labor relations law on behalf of management, and he represents his clients in that field with great vigor. He's known far and wide as Mr. Construction Industry. We're pleased to have Bruce Binning with us this morning as well. On my immediate left, bypassing our moderator, is Paul J.J. Cavalluzzo. Paul is a graduate of the Osgoode Hall Law School and of the Harvard Law School. He practices labor relations law on behalf of trade unions. He's a partner in the Toronto firm of Golden Levinson. He's a lecturer and an author, and his trademark in the profession is his objectivity and his intellectual integrity. We welcome him here this morning as a member of our panel. On my immediate right, we have Donald J. M. Brown of Toronto. Don is a graduate of the University of Manitoba, of the Osgoode Hall Law School, and of the Harvard Law School. He is, I venture to suggest, the only person who's ever articled for David Lewis and become a partner at Blake Castles. He taught law for a few years and then, for reasons known only to himself, has turned to private practice. He's now, as I've said, a partner at Blake's. And for those of us who travel the labor arbitration assizes around the province, we're frequently asked who this Brown fellow is who wrote Brown and Beattie, which is now the standard textbook in labor arbitrations. No one seems to believe that he exists. I'm pleased to tell you today that he does, except for the odd venture into the duck marshes of Manitoba, where he disappears to every fall. And we're very pleased then to have Don Brown with us here this morning as well. Our moderator, ladies and gentlemen, is the Honorable Mr. Justice Sidney L. Robbins. Mr. Justice Robbins is a graduate of the U of T Law School, of Osgoode Hall, and of the Harvard Law School. He lectured in torts, as many of you may recall, for years at Osgoode Hall, where he inspired many students. I recall that time vividly because at that time his lordship's hairstyle was not dissimilar from mine now, and so that he is very prominent in my recollection of those harried times. In his practice, he was a prominent general counsel, experienced in labor matters as well, and was appointed to the High Court bench in 1976. We're most honored to have his lordship here with us as our moderator today, and with that introduction, I'll pass the microphone over to him. Put this on.
How do we get this thing on? Is this good? Okay. Do I need one of those mics here, or is this going to carry? Okay, fine. Yes, good morning, ladies and gentlemen. The subject matter that's been assigned to this panel this morning is with respect to the Ontario Labour Relations Board's exercise of its remedial powers under the Ontario Labour Relations Act. As a matter of history, until the late 1960s, the attention of the Labour Relations Board was focused on the establishment of collective bargaining relationships. The board's prime function in those years related to union certification and the problems implicit in that issue. The board, of course, had some remedial authority over the conduct of bargaining and was provided with jurisdiction to make declarations of unlawful strikes and grant consent to prosecute for limited unfair labor practices. But jurisdiction over labor relations was, as it still is, divided between the board, the courts, and arbitrators. In more recent years, there has clearly been a shift in emphasis, with much greater authority being vested in the board. This stems mainly from the expansion granted by the legislature to the board with respect to its remedial powers, particularly the remedial powers given to the board in 1975 amendments to the legislation. The board's remedy now covers any complaint alleging a contravention of the Act, thus making its remedial authority available to any complaint in respect to any conduct covered by the Act. The prosecution route still remains, but it has been not often resorted to. Recognizing the sensitive area with which we are concerned and the increasing use of enforcement procedures under the Act, recognizing also the board's willingness to fashion new and stringent remedies, questions have arisen as to the efficacy of the board's orders and, as a matter of policy, how best the board might fulfill its function. These are fragile relationships with which we are concerned. Voluntary compliance with the provisions of the Act is, of course, important. There is always a danger, as we've seen recently, of mass disobedience of board orders. And the question of how the board can and should fulfill its function is one which has been raised by those who are interested in and practicing in this area of the law. The questions that have been devised this morning and have been put to us for discussion are designed to highlight some of the areas of controversy in respect to the board's remedial powers. I'm going to state those questions. I'll turn the matter then over to the learned gentleman on the panel for discussion, and if we have time later, ladies and gentlemen, we'll take questions from the floor in the hope that not me, but these other gentlemen will be able to answer. First of all, the question of general damages. The Kmart case, a recent decision of the board, and perhaps I should, before stating the question, remind you of the facts of this case, was one in which an application under Section 7A of the Act for certification of the employer, Kmart Canada Limited, was made. It was an application without a vote of the employees because, in the opinion of the board, the employer had so contravened the act that the true wishes of the employees were not likely to be ascertained. On that application, the union, in addition, sought damages for 2 of its members who were subjected to particularly intolerable treatment by the employer. 2 women were, in the words of the board, victims of what the board can only describe as a ruthless campaign of surveillance that endured for some 3 weeks. Apparently, a management trainee followed these women around at work for some 3 weeks to ensure that they would not organize the union. When they had to ask permission to go to the washroom. When they did, the management trainee followed them into the ladies' washroom in full view of the other employees. This, the board found, had the effect of ostracizing these 2 employees from their co-workers. In that decision, the board awarded damages to the 2 employees for, quote, humiliation and harassment, end quote, in the amount of $500. The board, in its decision, carefully distinguished that those damages, pointed out that those damages are of a compensatory nature and not punitive. In doing that, they were in keeping with the principle established in the Radio Shack case, of which you'll hear more, of course, later, and of which you are already familiar. The question arises with respect to the board's jurisdiction, if any, to award general damages for essentially tortious conduct and the criteria for making such awards. More specifically, the questions raised are these. When I say raised, I mean raised for discussion before this panel. Are general damages a remedy which could reasonably fall within the scope of Section 79(4) of the Act, or is the board going beyond its apparent jurisdiction and its area of expertise in awarding such damages? And secondly, if the board does have the jurisdiction to award these general type damages, these general tort type damages, which principles should the board use to quantify such damages? Should, for example, the foreseeability test, which is used in the civil courts, be used in the board's award of this classic form of compensation? Begin the discussion in respect to the damage remedy which has been awarded by the board in cases such as Kmart. I'd ask Bruce Binning to lead off.
I have grave difficulty with Section 79 and the interpretation that the court has now put on it, so I thought I'd start by giving you my opinion, but warn you that's not the law. If you read Section 79, the only reference to damages is in the form of compensation, which appears in subsection C of subsection 4. Now, the reason I have difficulty with the law as it now stands is that the award of damages, general damages, would have to be found in the general clause of subsection 4, which says that the board has a power to determine what a trade union, an employee, or an employer shall do or refrain from doing. Now, they have found in that general phrase the power to award general damages. And the thing that I have difficulty with, that the only reference in the section to any form of damages is to the most obvious one, which is compensation for lost wages. And why the legislature intended to give them the power or the jurisdiction to award general damages in a general clause and then mention the most obvious one, to me is just, it's incredible that the legislature would have, if they had intended, to have worded the section in that way. But that's my personal opinion. In my opinion, on a just strict reading, not even a strict reading, just any sort of a reading of Section 79, the board's jurisdiction, I believe, should be limited to the award of compensation for lost wages. But notwithstanding my opinion, the divisional court in the Radio Shack case said this, and I take this to be the law as it now exists. And the court said this in that decision: so long as the award of the board is compensatory and not punitive, so long as it flows from the scope, intent, and provisions of the Act itself, then the award of damages is within the jurisdiction of the board. Now, that appears to be the law as it presently exists. The mere fact that the award of damages is novel, that the remedy is innovative, should not be a reason for finding it unreasonable. Now, I think if you apply that, then the board is really free to do whatever it wants to do in regard to damages. Now, in particular reference, and the question that I'm supposed to address myself to, is the award of the $500 damages in the Kmart case. Now, the board said this in making that award, that where an employer has subjected employees to public indignity as a deliberate means of furthering its unlawful purpose, and the board concludes that no other remedy will adequately redress that particular unfair labor practice, it may deem it appropriate to order the compensation of the victimized employees to remedy the infringement of their rights under the Labor Relations Act. Now, as far as I am concerned, that reasoning is such that you can only lead to the conclusion that the damages in that case were punitive, because the board goes on to say that the award will have the effect of enforcing the order of the board in regard to the posting of a notice. In other words, surely, in awarding the $500, there's no question that they suffered $500 damages. That doesn't appear to be what the board has said. But the board is concerned with the unlawful activity, and is saying in order to set an example, and in order to make our general award in the Kmart case workable, then we're going to award these damages. In my view, they're punitive. I don't know whether this case is going to court, but I feel that definitely they do not have, even within the principle set out in the Radio Shack case, the power to do what they did in the Kmart case. Now, I believe that the court is going to have another look at it, because I think one of the problems, there was not too much sympathy, and should not be too much sympathy, for Kmart, Radio Shack, and Photomat in regard to certain of their activities. So certainly there was no sympathy, and I think that if the board makes an award in the future where the person against whom the award is made deserves some sympathy, I think the court will have another look at it. And just to give you an example of how far they've gone now with 79, in the construction industry, we have provincial agreements, whereas one of the clauses in the agreement is that an employer must make a contribution of 5 cents per hour to the employer's bargaining agency for the costs of negotiation and administration of the agreement. It's a reverse RAND formula in favor of the employer's association who negotiates the agreement. The board has recently found that the employer's association cannot collect that money from a delinquent employer by going under the collective agreement, but can do it by going under Section 79. So now, an employer's association can collect a contribution from an employer by using Section 79. Now, how you can read that into that section, I don't know, but that appears to be the result of the general license given to the board in the Radio Shack case. They're my initial comments. Sure.
Paul, what do you think? Are damages for harassment and humiliation punitive or compensatory, if that's the test? Well, before answering that question, I think it's important to note what the legislature did in 1975 when they amended Section 79.
Is it on now? Okay. I was talking about the amendment to Section 79 in 1975. It's important to note what the legislature did. If you look at the wording, the remedial wording in Section 79, you'll see that the language used there is of the broadest nature. The board basically can do anything to rectify the problem created by the violation, whether it be by a union or by an employer. Now, that language is the broadest that I have seen in this kind of collective bargaining legislation, and it seems to me that the legislature intended that the board would have this broad remedial power. Another point is that the amendment was made in the midst of the 1970s, where most legislatures across the country were expanding the remedial powers of labor boards. And I think it's important to note that since the time that the board awarded general damages, the legislation has been amended on a couple of occasions, and on neither of those occasions did the legislature feel it necessary to amend Section 79 so as to restrict the board's powers. Now, in respect of that question of whether the damages in the Kmart case are compensatory or punitive, it seems to me that any kind of an award of damages may have the effect of a punitive nature, in the sense that it encourages compliance with the legislation in the future, whether it be individually or on a broader scale in respect of other employers or trade unions. And it seems to me that the kind of conduct that we see in the Kmart case is of the grossest nature. It's of the kind that certainly I don't think any labor board could tolerate. And it seems to me something had to be done in respect of that kind of conduct. The two individuals involved certainly suffered humiliation and whatnot. This kind of conduct would have a grave impact on the organizing drive of the trade union, and it seems to me that the award of damages in that case were quite appropriate and in a compensatory nature.
You often represent the board. What do you say?
Well, you know, I listened to Bruce, astounded, and think that the court will have another look, and it seems to me that now gone to the Court of Appeal, and in effect all that the board has done is taken the language, and the court has agreed with it, is to fashion effective remedies to make sure that there's no percentage in it for anybody to willfully or otherwise disregard the legislation. And it seems to me that it's in the range of it's about time, and that the court is not going to feel that the board should be deprived of fashioning an effective remedy. And I think it's all over. In fact, I think on the legislation that the board should prima facie see it's having the ability to assess punitive damages if that is necessary to make the legislation effective, and that the language could be read to permit it to do so. Now, it's gone out of its way in Radio Shack and in Kmart to talk in terms of compensation only, but punitive damages in tort law in appropriate cases are certainly envisaged, although not commonly applied.
Claude?
Yes, I think that what we've seen here is a change in direction, not only on the part of the board, but also in the courts. I think that over the last 10 years, perhaps the period has been a little longer than that, the judges in our country have come to accept that the rule of law involves an acceptance of the supremacy of the legislature. And so if the legislature decides to give the Labor Relations Board far-reaching power like this and put a privative clause in place, the courts have finally come to accept that. That's the will of the people. Now, the practical consequence for us as citizens, of course, is that we have in place now in this province a tribunal that has the right to make orders of far-reaching financial significance without the procedural safeguards that exist in a court and without any right of appeal on the merits. In substance, because of some recent decisions, the board really has the power to define its own jurisdiction. That's because the courts have said that before they'll strike down the exercise of the board's power in the kind of area that we're now discussing, the court is going to have to be satisfied that the board's determination of its power under Section 79 is patently unreasonable. In other words, the court does not ask itself the usual question, do I agree with the interpretation given to the statute by the board? They ask the other question, is the board's determination patently unreasonable? And so, when one hears Mr. Binning express concerns about the power of the board, and when one is faced with legislation which is deliberately general and ambiguous, I must say I'm inclined to agree with Don Brown that I think it's very unlikely that the courts in this province, directed as they are by a decision of the Supreme Court of Canada only a couple of years ago, are going to interfere with that principle. And if they do that, then they'll allow the board, in effect, to fashion its own jurisdiction. And if the board one day decides that under Section 79 it must, in order to accomplish a legitimate purpose under the Act, require a collective agreement to be entered into, or direct that punitive damages be ordered, I think it's highly unlikely that the courts will interfere.
That leads into our next question, which deals with the matter of the board's fashioning a remedy, particularly fashioning a remedy which is not requested by the parties. These cases, as we've seen, involve innovative remedies, cases such as Radio Shack and Photomat, often going beyond the specific remedies requested or provide variations on the remedy requested by the complaining party. This leads to questions such as these. Is the board in dangerous waters in assuming jurisdiction to grant remedies that may not have been specifically requested by the complaining party? If the board is contemplating relief not requested by the parties, is it a denial of natural justice for the board to grant such relief without giving the parties an opportunity to make submissions, or do the parties simply throw themselves at the mercy of the board by being there? Would it be preferable if the board adhered to the more rigid principle of civil litigation that a remedy will not be granted unless specifically requested? I'm not sure that that's entirely so, or that that's a principle. But to lead off on this and carry on what you were saying earlier, I'll turn to Don Brown.
I think in looking at this question, or these series of questions, the first thing that we ought to do, recognize it's always nice to have a full opportunity to make your submissions on every possible point and alternative that might be chosen as a decision by any agency. But we have to look and make a distinction between what I call primary law and remedial law. I think it's of much more importance that the parties have an opportunity to present their arguments and submissions as to whether or not there's been a breach or behavior that would give rise to liability. Because that's the law that is speaking to the parties and telling them what they should do and what they shouldn't do, than it is for them to have a full opportunity in relation to the remedies. Because after all, they're really of a very secondary nature and not intended to have a direction on anybody as to how they're to behave.
$500,000 are being awarded in damages. Might be a little more than just procedural.
Well, $500,000 is a lot of money in some contexts, but it may not be in others.
I'm sorry to interrupt, but one of the issues that arises in this is there concern about the fact that this administrative tribunal is awarding, or can award on this basis, very substantial amounts of damages, or awards which involve the expenditure of substantial sums when you're appearing before a tribunal from which there is no appeal on the merits. And it seems to me that that's an issue to which at some point some attention might be directed. It may be that the only recourse is to go to the legislature. I interrupted your train of thought.
No, well,
I'm sorry.
Yeah, well, let me just carry on, and I'll come back to that. Let's deal with that right now. Judicial review of a damage award, it seems to me, still leaves open to a court to make sure that that award of damages doesn't go outside of generally accepted principle. It could be in excess of jurisdiction to fashion a award that was so excessive that it couldn't be reasonably related to the harm that was to be remedied, it seems to me, under our general principle. Secondly, that isn't very different from a court of appeals approach to a jury or a trial judge's award of damages in any event. However, let me carry on. In these circumstances, it's a little different than in ordinary civil litigation, where it may be left to the parties to determine the remedy they're seeking. Here, the board has an interest in the system itself. In fact, the board is directed by the legislation to administer the legislation and to administer a regime of labor relations through collective bargaining in the province. And it has an interest itself, apart from the parties, in determining that that system function effectively. Secondly, there are interests other than the parties that may have to be taken into account. And the Westinghouse case is a classic example where the board, in fashioning the remedy, had to take into account the rights of future employees not represented by anybody to exercise their freedom of choice in determining whether or not they wanted to be represented by a trade union.
Would you remind us what the remedy was there?
Well, the Westinghouse case was a situation where Westinghouse had moved its plant from Hamilton to some further town. One of the remedies sought was that the bargaining unit be enlarged to gather the new location within it, and the board refused to do that. In other words, but it did fashion a remedy that gave an opportunity and a damage award, I believe, that gave an opportunity to the union to conduct a campaign of organization at the new location and pay the cost of that organization campaign over a future period of time. That was not a remedy that was sought by either party, and it wouldn't have been because it was really to protect an interest of an unrepresented party. Finally, as to the dangerous water, it seems to me that, and maybe this comes back to your point, Sid, that there is a provision in the legislation to rehear any decision. So where the parties may not have asked for a remedy and got one that neither of them made submissions to, it can be reheard. And the board itself has on occasion caused the rehearing to occur just to permit those submissions. Secondly, there is an opportunity to go to the courts for judicial review in the case where the board might get totally off the tracks and commit a jurisdictional error.
Bruce?
One concern I have too is that to apply against the board the question of whether it has been reasonable or not, you must remember that the board is not a board of record. So they can make whatever findings they want on fact, and you're bound by those findings, regardless of what the evidence was. You know, and it's not a board of record. You can't appeal its decision. And in essence, a carefully worded decision can never be overthrown, you know, regardless of the evidence that they dealt with. And this is a real serious problem. And now on this business of rehearing, the principles of rehearing that they have applied, I mean, you'd never get anything overturned. I've never heard of anything being overturned unless there was new evidence that was not available at the time. So even on their rehearing, Don, I mean, that's a joke. The only good thing about all of this, I think the next time that we have an illegal strike, we're going to go under 79 for damages. You know, I think that's the right way to do it. So the sword does have two edges. And I'm sure that we'll spend a little time on fashioning our own remedies for employers. But really, I think that everybody's rights are going to be trampled on without any effective right of appeal, and I think we're in trouble.
Claude?
I think that it's important to remember that the power of the court to interfere is limited to a question of lack of jurisdiction. Obviously, a denial of natural justice gives rise to a lack of jurisdiction. However, the courts are reluctant to find a denial of natural justice and will only do so when they're satisfied that there has been a real, genuine unfairness which strikes to the root of the matter. The fact that the board gives an order which no one may have directly put their mind to is not necessarily going to result in a denial of natural justice. I want to revert to something Don Brown said. I'm concerned, I don't agree with Don, that the power of the court on judicial review is analogous to that of, for instance, the Court of Appeal reviewing a damage award by a jury. The Court of Appeal will send that award back for retrial if, in the view of the court, the award is so high or so low as to bear no reasonable relation, in the view of the court, to the injury that was being assessed. That says nothing about jurisdiction. It says nothing. The jury had the jurisdiction, the board has the jurisdiction. But in the one case, the court has the right to supervise and to say that award is inordinate and unreasonable. Now, what concerns me is that the court may not, in the face of this legislation, be given the authority to, in effect, say, a damage award of $1 million doesn't seem to make any sense to me. I mean, it's the board that's been put there to make that award. The only thing that gives me any comfort is that the history of this country suggests that faced with such an unreasonable decision, courts seem to have the imagination and the courage to interfere in those situations. What the legal basis will be is frankly beyond me at the moment.
Yes, Paul?
I just like to deal with one of the fears that many lawyers have, and that is that you have a statutory tribunal now dealing with damage awards of $500,000 or $1 million and so on, and someone said that we don't have the procedural safeguards of a court. I think that we're fooling ourselves if we think that the straight or strict judicial process is the only way to resolve a problem in today's society. The Labor Board is not the first statutory tribunal that will be dealing with huge sums of money. Just consider, for example, the Arbitration Board, which has been set up as a result of the recent hospital strike. Now, that tribunal has to determine the wages and the working conditions and the benefits for the employees. It seems to me that at stake there are millions and millions of dollars. Probably the most significant aspect of provincial expenditure will be dealt with at that arbitration hearing. Now, there are administrative bodies that deal with huge sums of money, and it seems to me that we don't have to have a court of law to deal with it. Secondly, it's important to recall that the Statutory Powers Procedure Act, of course, applies to the Labor Board, and that it seems to me that most hearings at the Labor Board are quite fair. And it's important to recall as well that the Labor Relations Act was not originally intended to be created for lawyers. It was intended to be a mechanism whereby laypersons could deal with their labor relations problems. And a court-like process would only, it seems to me, increase the expense and the time involved. Finally, there is, in terms of procedural safeguards, there is always the aspect of judicial review. It seems to me that this is the area where the courts will be playing their most useful function in the future, and that is the areas of denials of natural justice. The courts and the legislature, it seems to me, have a consensus now in respect of the interpretation of the legislation, that for the most part the Labor Board is a specialized tribunal. It was created to administer that legislation, and in most instances the court will defer to it. However, in respect of denials of natural justice, the divisional court in Ontario has indicated that it will intervene where it feels that the parties have been denied a fair hearing. And it seems to me that that is the proper role for the court to play in the future.
Another remedy that has come to the fore is one involving plant shutdowns, where a board has been confronted with a situation in which an employer has shut down or moved his operations to avoid a trade union and collective bargaining. In cases involving a plant relocation motivated by an anti-union animus, the board has ordered such remedies as the extension of the union recognition clause in the collective agreement to outside municipalities, as in the Humpty Dumpty case, and paying for the relocation costs of employees and organizing costs of the union at the new location, such as in the Westinghouse case to which Bruce made reference earlier. In purporting to extend the recognition clause in Humpty Dumpty, is the board amending an existing collective agreement with no apparent statutory authority, and in doing so, sidestepping the certification provisions of the Act? To follow that up, does the alternate remedy of requesting the employer to finance the union organizing costs at the new location run contrary to the spirit of the employer support provisions or prohibitions in the Act? Claude Thomson?
Yes, it's difficult to answer a question like that without going back to the facts of the case that give rise to the question. The Humpty Dumpty case is one that we should look at for illustration of the special kind of problem that the Labor Relations Board can be faced with. In that case, the employer had fought a lengthy battle with the union over certification. And there was a collective agreement that was negotiated with some spirit of animosity. And the evidence showed that the company was, to put it mildly, very displeased with its union and was, would look forward with some degree of glee to the dissolution of the union and the abandonment of the bargaining rights. Now, within that atmosphere, the company decided that it would relocate its plant outside of the geographical area in which the union had jurisdiction pursuant to the certificate. Now, the employees were told that if they wished to remain with the company, they would be individually assigned to one of the 6 new locations. And they were told that although they were free to remain union members, that the existing collective agreement would no longer be in force. So the board looked at all that and said that what that really amounted to was a threatened lockout. That while the company may have had some legitimate business reasons to move its plant, a significant motivating reason was to get rid of the union. Now, having made that determination, the board then, of course, had to, in its judgment, seek to put the matter right. How do you remedy that kind of a situation? And of course, what the board decided was that it might not be sensible to demand that the company return its operations to London, which was the original location. That might not have made economic sense. So what the board in substance said, well, it's up to you to fix it. Either send everybody back to London under the umbrella of the collective agreement, or if you're going to move them, the agreement's going too. And the social justification for that result depends on the acceptance of the board's original finding, that what had happened was contrary to the spirit and the letter of the legislation, and that no remedy apart from that alternative would accomplish the result that the legislation was intended to achieve. I guess what is frightening in these situations, and this was alluded to before, is that the board, while it obviously, and we must acknowledge, has enormous expertise in the field of labor relations, in making this order, this kind of order, the board also must be assuming considerable expertise in deciding what will be the real economic impact of some of these remedial orders, which have significant economic implications outside of the direct field of labor relations.
Bruce?
I don't have too much difficulty with the board in this area because they've been given specific powers to deal with corporate acts to avoid bargaining rights in Section 55 on the sale of a business. They've been given specific rights under Section 1.4 on common direction and control. So I don't have any great difficulty with the board acting to correct a corporate act to avoid bargaining rights. It seems proper that they should so act. They've been given specific power in 2 areas. Why not extend it to the way they have in those other cases?
Anything you want to add, Paul?
Just that I'm surprised that Bruce has agreed with the decision of the board. Anyway, in respect of the effect that this decision may have on a collective agreement, once again, we've got to refer back to 79.4, the remedial section. And what 79.4 says is that if it finds a contravention of the Act, the board shall determine what, if anything, the violator shall do or refrain from doing, notwithstanding the provisions of any collective agreement. So that the legislature has contemplated that in certain situations the board may have to override the agreement between the parties in order to enforce the legislation.
Pick up on something Claude says. The board may not be expert in determining the economic implications of some of its decisions found through the economy, but certainly they're as expert at determining what remedies will achieve the objectives of the legislation as anybody could be. Or they're in the best position that anybody could be to make that kind of a decision.
The Photomat case grants employees engaged in a lawful strike the right to apply to the employer for reinstatement beyond the 6-month statutory limitation in making such applications under Section 64(1) of the Act. Can the board use the remedial powers to which we've been making reference under Section 79(4) to extend such a statutory limitation? Or is the board assuming legislative authority in doing so? What do you think, Claude?
I don't think that the board is assuming any extraordinary legislative authority. Again, what's important is we have to go back to the facts of the case. What the board essentially found in that case is that the company, during the course of a lawful strike, was in breach of the law by failing to bargain in good faith, and by, in effect, making it reasonably clear to the employees, those who were on strike, that they really weren't welcome back. So putting those 2 factors together, after the 6-month period had expired, the board made a declaration that the company had not bargained in good faith, and made a remedial order that included an order that said, okay, start bargaining as of, I think it was July of 1980. But what we're going to say, in order to put the matter in the position it should have been in if the act had not been breached, is we're going to give all the employees until December of 1980 to apply for reinstatement to their former job, which is a right that they have under the Act. Now, it's true that under the section in the Act that purports to give them that right, they should have made the application within the first 6 months. But what the board essentially says is that the circumstances in the case were such that they were really disabled from taking advantage of the rights guaranteed to them under the Act because of the unlawful conduct of the company. So I don't have any difficulty myself with the jurisdiction to make that order. Again, I put it in these terms, I don't believe that any court is going to find that the board's interpretation of its powers in that case is patently or obviously unreasonable.
Bruce?
I don't agree with the board's decision at Photomat, but aside from that, I think insofar as that remedy is concerned, I believe that that's what 79.4 was directed at. And certainly the board should have that remedy available to them of, even if they don't refer to that section, extend the period for reemployment. I have no difficulty with that.
Just a few brief comments. Once again, the board in the Photomat case found a violation of the legislation. And what body better suited to fashion the kind of remedy that is required in order to have the legislation effective in the province? And I really have no problem with the board doing what it did.
I really don't have anything to add.
Well, perhaps this is a good time to break for coffee before we get into the question of injunctive relief. I think we might do so confident, at least the members of the legal profession here might do so confident in the idea that with these new remedies, whatever the original concepts of the board are concerned, the need for legal counsel is perhaps greater than ever before. We'll adjourn for 15 minutes.